Tonight, we're going to be talking about third-party influence, or TPI. And to that end, we're joined as usual by Dr. Pablo Bruera, who is a specialist in football law, as well as the founder and president of our parent company, Derechos del Fútbol and Football Council. And he is here to help us, as usual, to answer any or any queries you may have pertaining to this topic or any related topic. So let's just dive into it, okay? So some background to begin. Pursuant to Article 2G of the FIFA statutes, one of that is that's the article that pertains to the objectives of FIFA. One of these objectives of the governing body of football is to promote integrity, ethics, and fair play with a view to preventing all methods or practices such as corruption, doping, and match manipulation, which might jeopardize the integrity of matches, competitions, players, officials, member associations, or give rise to abuse of association football. To ensure this objective, FIFA has made a conscious effort to eradicate those activities and practices that pose a threat to football's integrity and are liable to tarnish its reputation and hinder the preservation of its essential values. One of these threats, and as a consequence of the football transfer market rapid and increasingly attractive growth, is precisely the possibility of negative and abusive third-party influence in football club affairs, especially in the transfer market. The proliferation of this type of transactions was and still is, in view of FIFA, detrimental to the autonomy of clubs to determine their policies and their independence in the decision-making process regarding their sporting and employment matters, as well as the recruitment and transfer of players. So also FIFA is of the view that the prevailing interest of third-party investors seems to be at odds with the principle of contractual stability pursuant to Article 13 of the RSTP. And that's only logical because the primary interest of an investor should be, in this case, that the player be transferred as many times as possible, because that way they will make more money, more return on their investment. On the flip side, the principle of contractual stability demands that contracts be honored the way they were signed and to the term and validity of said contract. So there's sometimes there can be somewhat a conflict there. So contractual relations between players and clubs, of course, must be governed by a regulatory system that is tailor-made to the specific needs of football, strikes at the right balance between the respective interests, protects players, and preserves the regularity of sporting competition. So the transfer of players in general, of course, is an area, as we stated, that is likely to give rise to conflict of interest. This practices also create the risk of interfering with clubs' freedom and independence. We're going to talk a lot about this further in the presentation, compromising football's integrity and reputation, as well as its essential values. It may also be highly detrimental to the very interests of players who stand at the heart of the international player transfer system. Moreover, the specificity of sports, we are in the world of the specificity of sports. Be lawyers, be agents, we need to understand that the specificity of sports permits some caveats to the general application of EU law. So, moreover, the specificity of sport, which has been expressly recognized by the European Commission as a legitimate objective, requires that the competitive balance between clubs taking part in the same competition be preserved. So, the provisions set out in Article 18 bis pertaining third-party influence are set in place in order to protect not only the autonomy and independence of clubs, but also the balance and integrity of the competitions, as well as the players, so they may have a say in the course of their career and where they want to go and how they want to go about their careers. So it's very important to point that out. That provision, that's the legitimate objective it aims for. So I didn't say this at the beginning of the presentation, but it's important for me to point out and for you guys for further study. Most of the material we have taken here is taken from the commentaries on the status and transfer of players of 2023. So there's a lot of case law there, guys, that you can check out and study if you so desire. So Article 18b, TPI on clubs. TPI stands for third-party influence. 1, no club shall enter into a contract which enables the counter clubs and vice versa, or any third party to acquire the ability to influence in employment and transfer related matters, also its independence, its policies or the performance of its teams. 2, the FIFA Disciplinary Committee may impose disciplinary measures on clubs that do not observe the obligations set out in this article. So various main topics, points. Parties involved in a transfer may attempt to secure financial gains, of course, by including clauses that can provide them with undue entitlements to the speculative investment made by persons or entities from inside or outside the football structure. Okay. In the world outside football, in terms of contracts, there's a number of clauses you might or provisions that you may put into a contract, right? But since the specificity of sports demands that there be a balance in competition, that the clubs be independent and be autonomous, there are some limitations to that freedom of contract. We're gonna see about that later also in this presentation. Such practices create the risk of interference with a club, again, freedom and independence in employment and transfer-related matters. Clubs may grant the counterparty or a third party the ability to influence or even control their decisions with respect to the transfer and employment contract of a certain player. Therefore, the provision on TPI on clubs was implemented to ensure that clubs remain independent and autonomous in order to make decisions that they deem appropriate in relation to the sporting needs. So it's not only transfers, it's not only employment matters, it's not only policies, but it's also sporting decisions. All in those aspects, the club must be independent and autonomous. So what's the FIFA Disciplinary Committee role? Well, it's basically competent to analyze possible infractions or violations of Article 18b. And there's a standard of proof, like we spoke in other live sessions. Pursuant to Article 39, Paragraph 3 of the Disciplinary Code, the standard of proof for the FIFA Disciplinary Code Committee must be comfortably satisfied that an agreement does not comply with Article 18b in order to impose a sanction on the club in breach. That is to say, why is this? This is because any breach on Article 18b would carry a disciplinary proceeding. And since it's a disciplinary proceeding, the standard of proof must be that of the comfortable satisfaction of the respective judicial body. So it's a burden of proof, a standard of proof that is higher than in commercial matters, but it's a lower than in criminal proceedings. But it still is a higher standard of proof than normal. So this assessment is made, the assessment of a breach of Article 18b, of course, is made on a case-by-case basis, taking into account all relevant elements of the case, aggravating and mitigating circumstances also. So this assessment, in the sense that it's made on a case-by-case basis, is backed up by a number of case awards that state precisely that the analysis, the assessment on the breach of Article 18b must be made on a case-by-case basis because it can change. And also, it has to take into account all the circumstances of the case. So let's talk a little bit about the concept of influence in regards to TPI. And we have chosen a couple of awards, CAS awards that back this concept up. These CAS awards are namely CAS Award 2020-8-716, Sport Club Corinthians Paulista versus FIFA, and CAS Award 2017-8-5463 Sevilla FC versus FIFA. And basically, they state that these panels found that the concept of influence means that one party acquires a real and true capacity to produce effects, condition, or affect the conduct of a club in a way that the club's independence and autonomy is clearly restricted. It cannot be something theoretical. The influence has to be real and effective. So the influence exercised by a party over a club does not need to be direct, but rather the effectiveness of the influence must actually impact the club decision-making capacity. Again, there's another CAS award there for your study if you so desire. And actually, CAS awards have determined that it's rather positive that there is no distinction between direct or indirect influence, because if there were, it would make it easier for the parties to circumvent the provision set out in Article 18b. So no distinction made. The influence can be direct or indirect, but it has to be real and effective. So this provision is irrespective of whether such influence actually materializes. What is really relevant is whether the party acquires the ability to influence, or in other words, where the contractual agreement provides the party with the capacity to exercise an influence over the club. That is to say, it doesn't have to exercise the influence, but the provision, if the provision gives that party the possibility, the ability, the capacity to exert that influence, and then it will be in breach of Article 18 bis, along with the other circumstances of the case, of course. Although the original purpose of the rule was indeed to protect the club from the influence of parties external to football, the improved overview provided by the transfer matching system of the international market led to the conclusion that the prohibited influence was also being exercised between clubs. So after the introduction of the TMS, FIFA found out that actually the clubs were also exerting influence over other clubs. And today, that is a practice more common than third-party influence. That is to say, clubs tend to influence more other clubs than third parties influence clubs to date. So in view of this, in 2015, Article 18 bis was slightly modified to the introduction of two words, vice versa. This is important. Why? With this inclusion, FIFA was authorized by his disciplinary committee to also sanction clubs exercising influence in agreement between clubs. Therefore, both the party that is exercising the influence and the club that is being influenced are prohibited from engaging in such conduct and therefore liable to being sanctioned by the disciplinary committee. The wording of the article does not distinguish, again, between direct and indirect influence. Okay. So the independence of a club, as referred to in Article 18 bis, shall be understood to mean the freedom of clubs to make decisions without being governed or controlled by other clubs or third parties. Now, this is in regards to independence. This means that no contractual agreement may impact the freedom of the club by including provisions that limit its autonomy in transfer, employment policy, and sporting matters, as stated before. So now this is a very important topic that we said we were going to go dive deeper, and it's the party's freedom of contract. It is clear that the provision under Article 18 bis may restrict the party's freedom of contract, which is a fundamental principle and right upheld by case law as well as Swiss law. Therefore, as a principle, clubs are allowed to freely set out the conditions stipulated in a contract, with only provisions violating mandatory law being prohibited. However, as the world governing body of football, FIFA is equally entitled to stipulate rules and regulations which may impose furthermore limitations on what would otherwise be the party's general freedom of contract. These limitations need to be proportionate, justified, and reasonable in order to achieve a legitimate aim pursuant to the function of the EU treaty. This is EU law, basically. This is the case with Article 18 bis as recognized by CAS and by various courts, such as the Swiss Federal Supreme Court and also the Brussels Court of Appeal. They all have recognized that this is a legitimate objective, but the limitations need to be proportionate, justified, and reasonable in order to achieve that legitimate aim. So some general considerations of FIFA case law and Article 18 bis. So after FIFA experience, these are some of the conclusions that they have gathered. In general, the case law related to Article 18 bis has determined that the influence required for a certain provision to be considered to be in breach of Article 18 bis must be, again, real and effective and impact the club's decisions. We're going to drill this idea in you guys because you're going to see that there are 4 or 5 main ideas that we need to know and understand and handle in regards to TPI. The prohibited influence will occur if another club or a third party has the capacity to actually affect and condition the decision-making process of the club in employment or transfer-related matters, or its limits its independence on internal or sporting matters. However, the influence, again, does not need to effectively materialize in order to trigger a violation of Article 18 bis. If the provision is in place, the circumstances are the right circumstances in order to exert that influence, right? In that scenario, doesn't matter if the party effectively imposes his will and limits the autonomy, it's only important that it has the capacity to do so.
O sea que también el intento de influencia podría ser sancionado, ¿no es cierto? Por este principio que estás diciendo.
Yeah, entonces, the intention, yeah, it can be sanctioned. But again, if the structure is in place in the contract, establishing a limitation, but the circumstances of the case do not make clear that that influence can actually be made, then it wouldn't be liable, even though the provision is in the contract. So it's on a case-by-case basis. But yeah, the intention can be subject to sanctions, of course.
Okay.
So now we're going to go about some type of clauses that are generally considered to be in breach of Article 18bis, pursuant to FIFA decision. So one type of clauses would be provisions restricting the new club with respect to the future transfer of a player. Some examples might be prohibition on transferring the player without the other club's consent, prohibition on transferring the player to a competitor club or making this subject to a higher penalty fee. We're going to see some case law about that. Prohibition on transferring the player until the transfer fee to acquire the player is paid in full. Remember that the international transfer certificate must be issued without conditions. That's very important, pursuant to TMS and a transfer matching system. Prohibition on loaning the player without authorization. Provision on assigning the player's economic right without consent. Ability for the other club or the third party to also negotiate the transfer of the player.
Okay.
Another type of clause would be provisions related to the employment relationship between the club and the player. And the two most common examples that we're going to see are inability to freely negotiate the terms of engagement of the player, obligation to prevent the player becoming a free agent, or establishing a penalty if it does. Provisions linked to selection in matches. For example, obligation to ensure that the player transfer on loan is fielded regularly. That is prohibited. Provisions obliging the club to communicate certain information. For example, and depending on the circumstances, of course, obligation to notify a player's injury, obligation to disclose every transfer offer. 5, provisions obliging the club to transfer or release a player under certain circumstances. For example, obligation to accept an offer for a specific transfer fee? No. That's very common, or used to be. Obligation to transfer the player in the event of relegation. Obligation to release the player for training and friendly matches. Obligation to transfer the player before a certain date. That's another one. So finally, provisions granting other type of influences. Ability to select new players for the team jointly with the new club. Ability to decide the market value of the player jointly with the new club. Ability to force the club to acquire the share of the player's economic rights belonging to the third party. Ability for the third party to acquire players for the club, retain their economic rights, and decide when and how to transfer them. Oh, come on, buy the team already, right? So now we're going to go about some clauses that generally are not considered to be in breach of Article 18bis. Again, this is on a case-by-case basis, and if the circumstances so warrant, some of these clauses might be in breach of Article 18bis if the case may be. So, but regularly, they are accepted. Sell-on fees. Sell-on fees are generally recognized and accepted by FIFA and CAS. The compatibility of a sell-on fee with Article 18bis might be questioned, though, when a club tries to safeguard its economic interest in a player by including provisions in the contract that have the capacity to restrict the independence of the club where the player is or will be registered. 2, performance-related bonus. This is perfectly licit. Conditional payments for successful individual and collective results are to be regarded as positive influence. So not all influence are prohibited. It has to be a real and effective influence, and it has to be unreasonable or unacceptable, but positive influence are accepted by FIFA and CAS. Basically, those that reward the player for a number of games played, for qualifying to a different phase, for scoring a number of goals, etc., for having a number of years in the club. All those bonuses are perfectly legal within the framework of FIFA. So they are aligned with the sporting principle in which football is based and are therefore generally regarded to be beyond the rationale and objectives of the provision. Therefore, they are permitted in principle. Matching right option, also the right of first refusal. Although in this type of cases, the new club contractually agrees to limit its autonomy to decide the club to which its player will be transferred. This limitation, although it's a limitation, this limitation does not constitute sufficient influence so as to trigger a violation of Article 18b since the new club, and these are the reasons why this influence is not sufficient to be a violation of Article 18b. The club can always freely decide to reject the transfer offer, and also will not receive less money for transferring the player back to the former club. So it's okay. If those conditions are met. Sorry. Buyback options. The mutual predetermination of a transfer fee for the former club to buy back the services of the player does not constitute a sufficient standard of influence to consider that the new club is influenced. Again, there's an influence, but it's not sufficient. Predetermined fees are also common in loan agreements where the loaning club gives the option to the loaning club to acquire the player on a permanent basis following the period of the loan. In these buyback options, one has to take also into account national applicable law. Why? In some countries, the buyback option is not permitted. It's called in Spanish pacto de retroventa. In some jurisdictions, it's not allowed. So one also has to be acquainted with the national applicable law in order to properly assess a client. So automatic conversion of a loan agreement into a permanent transfer. The fact that meeting certain conditions in a loan agreement obliges the loaning club to acquire the player on a permanent basis does not mean that the autonomy of the club is restricted in such a way as to consider it a prohibited influence. Again, the club limits its autonomy, but that's part of the freedom of contract, right? But it's not to an extent that it's going to be considered as a prohibited influence.
Luis, sería el caso entonces que si el jugador juega el 50% de los partidos, el club que lo recibe a préstamo tiene obligación de compra. Eso no es influencia.
No sería, o por ejemplo, no.
Este caso, ¿no? ¿Este es el caso?
Ese es el caso.
Okay.
An example even would be if the club goes to a higher division,
okay,
then you have to buy the player, for example. That wouldn't be in breach. Again,
okay.
No, provided that the circumstances in the case are not different than the normal, contractual terms.
Okay, perfect.
This is a good one also. Automatic payment, it gave me ideas. Automatic payment of a fee to the former club every time the employment contract between the new club and the player is renewed. This is a good one. So every time the player has a new contract with the current club, the former club is going to be entitled to a fee.
Okay.
That's yeah. So a clause triggering a certain incentive is also pursuant to RSTP regulations and not in breach of Article 18b. So there are some contractual agreements that have been recently investigated by FIFA. Some are exactly like the ones we talked about before, and some are somewhat different, but there's some case law attached to it for you to study, and you can have the presentation for your perusal. So, one, agreements between clubs granting prohibited influence, because we're also going to see agreements between third parties and clubs. This is between clubs. A, provisions restricting the new club with respect to the future transfer of a player. That's the most common one. Transfer of the player to a competitor club subject to a higher penalty fee. So let's make a stop here. Okay. Transfer of the player to a competitor club subject to a higher penalty fee. Even though the clubs that have agreed to that provision might be subject to disciplinary sanctions by FIFA, it can occur that the agreement under applicable law in an arbitration court or a judicial court may be valid. So the scenario might be this. A club might be sanctioned by FIFA, but it's going to be obliged to pay the monies and the penalties. That scenario can happen. So it's very important for us to know the applicable law. Again. Provisions linked to selection for matches. Appearance of the player in a match against the club which loaned them subject to a fee. Again. Obligation, commitment that the player transfer on loan is filled regularly. Those are prohibited. Provisions related to the club employment relationship. Same two scenarios. Obligation for the club to prevent the player from becoming a free agent or paying a fee if it does. inability to freely negotiate the player's terms of engagement. Same examples are being very, very much scrutinized by FIFA. So provisions obliging the club to transfer a player under certain conditions. For example, obligation to accept an offer for a specific transfer fee or pay a penalty fee. That's like the bread and butter. So now, and are basically fewer examples, but the same ones, agreements between a club and a third party granting prohibited influence. Clauses restricting the new club with respect to the future transfer of the player, same. Impossibility to freely decide to transfer a player, for example. Clauses obliging the club to transfer a player under certain conditions. Again, obligation to accept an offer for a specific transfer fee or pay a penalty fee. I don't know if there are any questions at this point. Let me see.
Creo que ya estamos bien. La influencia tiene que materializarse, o el intento también, ya lo dijiste, que era también, y si la influencia se puede establecer de oficio, o tiene que ser a pedido de parte, y en definitiva creo que también, ¿no? La FIFA puede de oficio mirar un contrato y establecer que hay una influencia, ¿no? Pero bueno, contame eso, si querés un poquito.
Yeah. So Pablo was pointing out something very important. So can FIFA ex officio enter and investigate if there's a TPI in a relationship, in a contractual relationship? I would say yes. It has ample powers in the statutes. That's clear enough. But also, since the party have the obligation to review and submit any and all contract that they have subscribed in regards to a transaction, if they don't, they're going to be liable also. So my question, my answer would be yeah, for sure FIFA could ex officio investigate TPI and TPO violations.
Muy bien.
In the more recent jurisprudence from the FIFA Disciplinary Committee and the FIFA Appeals Committee, the following trends could be observed. This is the more recent FIFA Disciplinary Committee and Appeals Committee decisions. They have determined that those clauses which establish a significantly higher or a penalty fee should the player be transferred to a competitor could generally trigger a violation of Article 18b, since in the event of two identical offers, of course, the club would always be inclined to accept the offer which makes the operation more financially profitable. But maybe that's not what the club wanted to do. Maybe the club was more oriented to a sporting decision, but this higher fee just detracts him from doing that. It has been re-emphasized also that in order to be considered truly independent, clubs shall be free to transfer their players to any club they desire. The conflicted provision must provide, again, a real and true ability to restrict the club's autonomy and independence. This is going to be drilled down, guys. The wording of Article 18b is intentionally broad in order to encompass all possible types of undue influence on clubs. This is in relation to the predictability test that we're going to talk about in a few minutes. But there's a predictability test that all sanctioning provisions must have it. That is to say, we have to know in advance what conducts are prohibited and what are the sanctions if we incur in them. That test is complied with by Article 18b, and that's pursuant to CAS jurisprudence. Recent consideration from FIFA case law, again, there has been the first ever decision considering a clause to be in violation of Article 18b, where the loaning club needed to pay a fee to the parent club should they want to field the player in a match against them. In this regard, the FIFA Disciplinary Committee considered that the clause in question instigated the club to refrain from yielding the player in an eventual match against the other club due to the negative financial impact that doing so would involve. Therefore, the club would not enjoy complete independence with regard to its policies and the performance of its teams. Pretty clear. Also, there's a difference between, and this is very important, and I learned this from Dr. Pablo Bruera, a conditional bonus payment for yielding a player that's a positive influence, and penalties for not being yielded, for not being fielded. So, why is that? Because what FIFA is looking for is that the player has more exposition, plays more, be more developed each time, you know? So, but in a positive way, if you can make an incentive rather than a penalty for that player to play, that's perfectly valid. If you sanction a club, basically obliging the club to field that player, that is in breach of Article 18b. So It's also important to note that it has been reconfirmed that a provision which, subject to a significant penalty fee, prevents a club from allowing the player to become a free agent without the former club receiving a share of the economic rights of the player, results in a violation of Article 18 bis. So if a club prevents a player from becoming a free agent, it's in breach of contract. If that player becomes a free agent and the releasing club has to pay the former club a penalty, that's a prohibited conduct also. So nothing can prohibit, those positions are basically automatically in breach. But again, we gotta go on a case-on-case basis. CAS has recognized the validity of Article 18 bis, the objectives pursued with implementation, its binding nature, and its compatibility with Europe. Now we're gonna dive into some considerations of the Court of Arbitration for Sports regarding TPI. In particular, CAS has considered that Article 18 bis does not violate, limit, restrict, or unlawfully affect any of the fundamental freedoms of the EU, and that the rule seeks to achieve a legitimate aim that is aligned with the specificity of sports. This interpretation was also confirmed by various ordinary courts. Again, the Swiss Federal Supreme Court, when they try to annul the CAS awards, and also the Brussels Courts of Appeal back this decision. More recently, CAS has also analyzed and interpreted the application of Article 18 bis to various contractual agreements signed by clubs with other clubs or third parties, and in particular, the concept of influence and independence. The main considerations and conclusions are as follows. Article 18 bis, again, this is the point we were talking before. Article 18 bis meets the predictability test. It is sufficiently clear and precise in prohibiting clubs from entering into contracts that enable other parties to acquire the ability to influence the employment and transfer-related matters, their independent policies, or team performances. The fact that Article 18 bis can capture an unspecified variety of contracts does not mean that it lacks sufficient legal basis and predictability, because the parties subject to FIFA regulations know that TPI is a prohibited conduct. They know it in all his different ways to apply it. So that's sufficient for them to know what's the prohibited conduct, and all the sanctions are set out in the FIFA disciplinary code. So both the conduct and the sanctions are set out, and the parties know what to expect. So the predictability test is there met. Article 18 bis, in the context of Swiss law, must be interpreted narrowly, given its potential to significantly restrict the contractual freedom of the parties. However, it is also of the utmost importance to safeguard the independence of clubs. There's a balance here, right? There's the freedom of contract, which is paramount, but also is the importance of maintaining independence of club to protect the integrity of competition, to protect the players as well, and to protect also undue influence on the clubs. So a hypothetical or a theoretical influence should not trigger a violation of Article 18 bis. However, the club might also be found guilty of the prohibited conduct if the contract effectively enables the said party to have an influence on the club in such matters, regardless of whatever this influence actually materializes. We were talking about before with Pablo. The conduct, the influence doesn't have to be exerted, but if the party has the party has the ability, the capacity to exert that influence, you're already in breach. Okay, so the influence shall be considered unreasonable or unacceptable towards the protected value of the provision. It not only have to be effective and real, but it also have to be considered unreasonable and unacceptable. Remember, there are permitted influence, positive influence in FIFA's language. A high threshold should be applied to determine whether a certain provision goes against the spirit of Article bis. And that high threshold is the comfortable satisfaction of the judicial body, has stated before. That's not the burden of proof, the standard of proof. So even when there could be contractual structures where an undue influence may be established, the particular circumstances may not make it sufficiently unreasonable or unacceptable for a violation of Article bis to be triggered. So maybe there's a provision that grants an unwanted influence on the other party, right? but the circumstances just don't make it possible for the party to enforce that capacity. So in that case, 18Bs wouldn't be triggered. The particularities of the agreement, the clubs involved, or the nature of the provision may have an impact on the consideration of whether a violation of Article 18B occurs. At the end of the presentation, we're going to see some factors that are taken into consideration in order to assess if a violation of Article 18B occurs or not, pursuant to FIFA and CAS decisions. All factors surrounding a conflicted provision shall be examined, and there must be a case-by-case appraisal of the potential impacts. That's very important. Any questions to this point? ¿Alguna pregunta?
Bueno, típica sanción, capaz que lo tenés después, por eso no te quería... Es una multa, ¿no?
That's a very interesting question. So, Pablo asked, what are the usual sanctions that FIFA imposes? Basically, they're monetary sanctions, and case law has shown us that they range between 10,000 euros and 187,000 euros to date. But there have been times also where clubs have been prohibited from transferring players for 1 or 2 or windows, depending on the severity of the case. But basically are monetary sanctions, yes.
Okay.
So this is what we were talking about. Excuse me. So taking into consideration the relevant case law from FIFA and CAS, the following factors in particular shall be taken into account when assessing whether a certain provision might violate Article 18B. So if you are an arbitrator or you are in a panel in FIFA, this is what you're looking for in order to assess if a violation of Article 18B occurs. The legitimate objectives of the agreement, the positive or negative nature of the clause concerned, remember that there are positive influences permitted, the context in which influence is exercised, whether the parties freely negotiated the agreement or suffer any restriction, the status and sporting and financial position of the clubs involved, because usually bigger clubs tend to impose their conditions on smaller clubs, sporting or economic impact of the clause, the number and economic value of the players for which the club entered into a contractual relationship, or the prominence and market power of the clubs and companies involved. It follows the same rationale. Some party is going to be more powerful than the other and going to impose the terms and conditions. So that's important to take into consideration. And finally, since the TMS is a mandatory in international transfers, we wanted to point out some aspects in regards to the declaration on TPI by clubs in the transfer matching system. It shall be noted that when clubs enter into an international transfer into TMS, the club engaging the player must either declare yes or no in response to being asked where they have entered into a contract which contains a TPI, third-party influence. By incorrectly declaring that there is no TPI, club failed to disclose full mandatory and correct information in the TMS. Therefore, an infringement of Article 18B also includes a failure to provide the mandatory information or entry of incorrect information in the TPI declaration TMS. Guys, be very careful, not only of not providing the information, but providing incorrect information, because as we spoke with a little bit before, monetary sanctions are quite high. So that will be all for tonight. I don't know if there are any questions at this point.
Muy buena, ¿eh? Congratulations. Congratulations.
Thank you, Pablo.
Entonces, los que pueden ser sancionados, Luis, son los clubes, ¿no es cierto? Los clubes que han estado en la influencia. ¿El jugador podría ser sancionado?
Okay, that's a good question. So Pablo asked, Pablo affirms that only the two clubs the clubs engaging are the ones that are being liable to sanctions. Of course, because the third party is not part of organized football, so it's not liable to the stipulations of FIFA. Okay. But the player is. So the player won't be, maybe, and we're discussing, speaking out loud, the player may not be liable for precisely for TPI or TPO. I don't know, because it's usually clubs. I don't have that experience, But what I can tell you, if the player participated in a way that permitted this type of negotiations, some type of sanction, I think, is in place. Yeah.
Bien. Bueno, congratulations. It's not us. Finish.
No more. Okay,
No more.
So no more questions for tonight. And then please join us next Wednesday. We're going to be talking now about same time. We're going to be talking now about third-party ownership. We're going to compare it somewhat with the third-party influence and some case law. But we're going to be announcing that during the week in our social media accounts.
To divide 18 Bs and 18 third. Yes.
Okay. So let's do it that way, Pablo. So if nothing else, be safe until then, guys.